Well, good morning. I'm glad you could come. Glad I could be here as well. Before we start, though, I'd like you, if you would, to indulge me about 5 or 10 seconds silence for my partner, Jack Curtin, who died battling 3 kinds of cancer for the last 10 or 15 years. A great leader of the bar, president of the ABA, great trial lawyer. His funeral is today. Thanks, Jack. Well, Jack was not a gloom and doom type guy. He wouldn't want to cast a pall over a group of colleagues addressing such a scintillating topic as discovery of electronic data. So let's get at it. First, I'd like to give you a little background music. I think perhaps my own career here could illustrate where we were, where we have come to. I started practice, as someone just said, at Bingham, Dana, and Gould in 1963. And my experience was general litigation, 50-50, state court, federal court. And there was a remarkable difference in the culture, in the outlook, in the procedures, in the ingrained habits between the federal and the state courts then, to some extent now. Now, at that time, the federal courts were in the bloom of enlightened discovery. They, ever since the federal rules had been adopted in 1937, every year saw additional amendments in the direction of full, free, factual discovery. The federal system was dedicated to the concept that justice required full access to the facts. And they took great pride in the rules that they had enacted to bring that about. Now, they did not adhere to the ancient practice of secrecy, hide the ball type tactics and rules. What's my evidence? What's my witnesses? What's my theories is mine. You can butt out. That was indeed what I perceived to be the theory of the state courts that I practiced in at that time. So there were very different approaches to the solution of the trial of civil cases. The federal rules had unlimited depositions, unlimited interrogatories, including contention interrogatories, full pretrial motions, full document discovery. The state courts had 30 interrogatories and an occasional motion for specifications, which were poorly understood by the judges. So I just went back and forth between the two systems. They were fine. I didn't have any problem with either of them. But for the last 30 years or so, I have been rather intimately involved in the rulemaking process, federal and state. I went on the American College of Trial Lawyers Civil Rules Committee in 1983. I'm still there. I was chairman of that committee for 5 years. We worked very closely with the Judicial Conference Advisory Committee on Civil Rules. Actually in the 1990s got appointed to that committee by Chief Justice Rehnquist. Another fellow here was with us, John Carroll. He was on that committee with us. And so year in and year out, from the American College, working very closely with the Judicial Conference, and then on the advisory committee itself, I got exposed to some pretty heavy rulemaking experience. Now, in 2007, I was appointed to the state advisory committee, Judge Rutberg's committee, Standing Advisory Committee on Civil and Appellate Litigation. and he appointed me chairman of the ESI subcommittee. So I'm still on these various committees I've mentioned. And here it is, many years later. Well, let's focus on discovery. The first 30 years or so of the Federal Rules of Civil Procedure, from 1937 up to about 1970, there was an emphasis, unambiguously, on amending the federal rules to achieve more and broader pretrial discovery. Unmistakably, that was the philosophy. But along about 1970, the wind started to shift, slowly at first, and then with an increasing velocity. Discovery shifted from the fair-haired child, noble handmaiden of justice, to its present persona, where it is perceived as a ravenous wolf gobbling up funds, consuming energies, and sucking the economy's lifeblood out of it. I've seen that change. At this moment, there are 86 pages of proposed amendments to the federal rules, all of them designed to cabin, to curb, to restrict, to limit discovery. It's seen as a matter of self-defense. Civil litigation may go the way of the horse and buggy if something isn't done, or at least that's the perception. The state system has lagged behind a respectable distance, behind the feds, but they're not immune to these pendulum swings. Just to epitomize the difference between the state and federal systems here regarding discovery, as of December 1, 2006, when the federal rules were amended to bring in ESI discovery, the Federal Rules of Civil Procedure had 26A, automatic disclosures, 26B1, very narrow, somewhat narrower view of what is discoverable than the states. 26F, mandatory meet and confer conferences. 26F, discovery plan will be submitted by the parties. Rule 16, conferences with the judge. Rule 16 is worded in discretionary terms. Every one of the districts has a local rule that requires a Rule 16 conference. Well, there was Rule 38-2, 10 deposition limit. Rule 26D1, 7-hour limit per deposition. And of course, there were the extensive ESI rules that came in December 2006. And here was the state rule that had adopted the federal rule as of 1974 at its height of permissiveness. So after 1970, as I've said, each of the amendments that have been proposed and occurred have been in the direction of curbing this discovery phenomenon. And the philosophy has changed, and the structure has been created whereby you can hang different limitations on it. The state has nothing similar to that. But the SJC, after the federal rules got amended to come up with some ESI rules, asked Judge Rutberg's committee to look into whether we should have some rules in the state courts, and if so, what they should be. Let me go into our efforts at that point. I was head of the ESI committee, subcommittee. I'll do a lead-in here, and then we'll transfer it to Judge Rutberg, who will give you more detail on some of the nuts and bolts here. there were many problems, differences between the federal and the state courts at that time. Now, in Massachusetts, there are 7 separate court systems. There may be another one. I can count the Superior Court, District Court, BMC, Housing, Land, Juvenile, Probate, and if I missed one, okay, there's 8. Those are different systems. They have their jealousies, they have their concerns, they have their culture, they have their ingrained habits, and there is one unitary federal system. Sure, it's huge, a huge number of cases, and there's all kind of cases in the federal courts, but it is a uniform system, more so than the 7 systems here in Massachusetts. And the SJC, we believed, wished to have uniform rules applied to all those courts. And frankly, it would be a little easier to do it in this federal court with all their judges and their geographical differences than here. So anyway, that was a big problem if we're going to come up with a uniform set of rules. Another big problem I found was the degree of pro se litigation. That will differ among the various state systems themselves, and it will differ in quantity between the state court generally and the federal court. Sure, there are federal pro se cases, but nothing like what is to be found in, say, the housing court or the probate court or any of the others. So we had started out with the idea we're going to have some mandatory stuff here, mandatory conferences and so on. We decided, we met 3 or 4 times, we brainstormed. I was brainwashed. I hope you didn't notice that. We consulted various sources. Judge Collins from the federal court is maybe the best expert in the country on ESI discovery. We consulted the written sources. The uniform commissioners proposed state rules. The chief justices of the various state courts came up with a manual and a database of good practices. Chief Justice Marshall was the head of it at that time. So we looked at what was out there. And what we found was that the principal tools to control ESI were early attention by the parties and the judge, such as meet and confer sessions, expenditure of time and effort right up front to tackle these problems and to address them before they degenerate into litigation disputes. For instance, what's the form of the response? Well, if you decide halfway through that the party responding is using the wrong format or not doing it in the right form, that's a problem. And one of Judge Collins's great advices to us was get that thing set right away. But there are a lot of other such requirements that will lead to less grief. Okay, in essence, we were tasked with trying to come up with some procedures that would accomplish a change from combat to cooperation, and that was what we think we have done. Perhaps in the rules, maybe not in the conduct of the people, but if the system is to survive, there has to be some kind of controls put on it. And there is no history or culture of mandatory early attention to these matters under the state rules, state courts. When we started out, we thought we would adopt what the feds had done. And the components of the various court systems and the people on our committee made known to us, we think, mandatory anything was not going to be well received. Okay, so we don't have mandatory conferences. Now, what we did do, we split the task up into what would be good rules, freestanding rules, without regard to whether you have a conference or consent, if there is a dispute. And we have come up with 6 or 7 of those kind of rules. And then on the conferences, should you have conferences, we have left those to the discretion of the judge and the parties. Now, for the freestanding rules, we have the clawback system, 26B5. Doesn't depend on any kind of cooperation among the parties. We have a res judicata part of that, 26B5. If the judge rules on a privilege, no other judge anywhere, even in Alaska, can undo that. We have the 2-tier system, whereby a party served with a document request can say, no, I'm not even going to search for that. That was 3 computer processes ago here, and I'm not even going to bother to search. It's inaccessible because of expense. So we have various of these requirements that will be there, and we think they're useful, whether there is consent about them or not. But when you get to the conference and the Rule 16 conference with the judge, they are discretionary in what we have come up with. Will they work? Well, I'm going to leave that to Judge Rutberg to tell us whether they'll work or not.
This is a great privilege for me to be here. I'm really grateful. I want to say thank you to Evidox for putting on this conference and inviting me. You know, like Dorothy says, this ain't Kansas, Toto. When you sit in the district court in Pittsfield, come down to Boston and get to see the harbor and be in front of a crowd of distinguished civil lawyers, it's not exactly the first session in the Springfield District Court. But I also want to mention that the title of this segment is why it took 6 years for these rules to come about. And as Fran indicated, Chief Justice Marshall was involved with the Association of State Court Chiefs, and she was interested in this, and she suggested it to my predecessor, and he left that on the table. When I became the chair of this committee, I didn't know anything about it, and I appointed Fran to be the chair of the subcommittee. But and that subcommittee, I can't tell you how hard they worked to come up with this. And when you look at when you hear these rules, they may not sound like a whole lot of things that were done, but to get where we got, it didn't get there inadvertently. Everything was thought out and talked about and hashed over again to preserve the culture of what we have in Massachusetts, at the same time trying to affect these long-term goals of making discovery manageable and making e-discovery, bringing it into the 21st century. Our committee has a liaison with the SJC, and she's here, Chris Burek, and I want to thank her for her participation. I mean, she's a rock. And in addition to that, the official reporter for the Massachusetts Rules of Civil Procedure, Professor Mark Perlin of the Suffolk Law School, and of course they're a sponsor here. And Mark and Chris have made my job as the chair incredibly easier, and have offered real wise advice to the committee. And as a practitioner, I never really paid too much attention to the reporter's notes, and maybe not as a judge till I got involved with these committees. But you'll see the reporter's notes with respect to these changes. I commend them to you, and especially Mark wrote an extensive note that's published with respect to Rule 26. The amendments deal with Rule 16, 26, 34, 37, 45. But the bulk of them, though, come in Rule 26. And so in the reporter's notes for Rule 26, you'll see there's about a 3-page description of how we got where we got, how we got to where we got, and why. And I commend that. It's certainly be useful. And in doing so, Mark identified 4 areas of major focus that our committee, that we were trying to address here. Number 1, to enable as well as encourage the parties in the courts to deal with ESI early. 2, to manage issues regarding inaccessibility. 3, to acknowledge that privileged ESI may become inadvertently produced and therefore provide a remedy for that. And finally, to provide protection when ESI is lost in normal business operations, spoliation issues. And so I'll just go through these to get these areas of focus, and in doing so, I'll pick up the rule changes rather than going through the rules themselves one at a time. With the early intervention component, and that Fran talked about at some length in his talk, is really the key to this whole thing. And the problem is the culture, certainly in the Superior Court, is not to have pretrial conferences until you get right to the end of the process. And we did not want to upset that culture for various reasons. First of all, because most cases that involve ESI are not going to have ESI conferences. Most of the cases, it's all going to, at least that's how I perceive it, it's all going to be requested and produced according to the way it's been done up to now. Someone's going to say, I want to see all your emails, and probably they'll print them out and hand them over. At least that's what they do in the district court. Perhaps in the more sophisticated part of the state here in the eastern part, they'll burn them on a disc and send you a disc in the mail. But that's going to, that's my prediction as to for the bulk of the numbers of cases. But what you all represent are the bulk of the amount of the ESI that's going to be produced, the larger cases. And that's what we have, what we need the conferencing for, and the ESI rules. But we didn't want to upset the culture of the court system because of a small portion of cases that are going to require this. So Rule 26 allows any party to ask for an ESI conference within 90 days. And we require that you have to do it within the first 90 days because we want to get this thing moving. And then the conference has to happen within 30 days thereafter. If that, beyond the 90 days, anybody can ask for one, but then the other party doesn't have to even participate. And the fallback, of course, is going to the court for a Rule 16 conference. And then, so the idea is first you do it yourselves, and if you can't do it, come to the court. 26, the bulk of what is new is in 26F, which is a brand new section. And 26F2 sets forth the procedure and the agenda for an ESI conference. This is all, you're going to get all this stuff. And I know when Mr. Sabloni speaks to you this afternoon, his piece has the law in it, a printout of the new statute, so you'll get it all too. So the things that are to be talked about at an ESI conference, this is again, a voluntary conference, issues relating to the preservation. Well, if it's up there, you can read them yourself. Things that pretty obvious. Issues relating to the preservation of discoverable information, the form, metadata, the time in which it's to be produced, how we're going to preserve claims of privilege and confidential status, allocation of expense, etc. If that doesn't work out, or if it does work out, if the parties come to an agreement, you can still take it, and we encourage it to be taken to the judge and get the judge to sign off. There's a reward at the end, and that's what I want to get that in a moment, and that's the clawback. If it's signed, if there's an order having to do with privilege, the clawback then not only affects the case at hand, but all other litigation. Now, we don't know how that is going to affect, what courts are going to do in Alaska with what some judge in Pittsfield did, but at least it's written that way. And that is written as an incentive to take these, to first of all, do it yourself, work it out. You don't need the judge. But if you do, take what you need to the judge and get the judge to sign off on it. And then 26F3 talks about the hearing before the judge, and you'll notice that the agenda, the purposes are almost verbatim as to what's in the conference, except for the very first one that says whether discovery of the information is reasonably likely to be sought in the proceeding. And as I read that over, I'm a little dumbfounded as to why we put that in there, but we did. So the point is, make your deal, go to the judge, get him or her to sign off on it if you can. And the next thing we have to deal with, of course, the big part is inaccessible. What is inaccessible? And inaccessibility is contained in, again, in Rule 26F, subsection 4. Now think about 1 and 4. 1 is the definitional section for 26F. There's only one definition, and that is inaccessibility. And you'll notice that the definition is almost circular. It says that inaccessible electronically stored information is that which the party identifies as not reasonably accessible because of undue burden or cost. So that is the concept, and that is barred from the feds as well. So again, uniformity among the systems is a goal that we aspire to. And it's one that the SJC seeks. Every year I have to report to the SJC about changes in the federal rules, and we report what they did, what we're doing, and there is always a policy to try to keep as much of this congruent as possible. 26F4, though, sets out how we deal with inaccessible information. Subsection A allows the party to object, saying that I think it's inaccessible, but it requires the party to state the reasons for the inaccessibility. Subsection B puts the burden of proof on the party claiming inaccessibility to prove it. And then subsection D sets a standard for judicial determination of inaccessibility. And that standard is whether the benefit of obtaining the sought-for discovery exceeds the burden placed on the party from whom it is demanded. And if it is determined to be inaccessible, understand it's still discoverable and still can be produced. And D and E talk about how we're going to deal with the discovery of inaccessible information. And subsection E specifically gives the court a set of 4 criteria to deal with what you're going to do with inaccessible, the actual discovery of ESI that's deemed to be inaccessible. And the key here is the allocation of expense. And so the theory behind all of this is we're going to try to attack this from the demand side. If you want it, you're going to pay for it. If you want it, you're going to get it, and we're going to encourage the other party to give it to you. Now, not just with respect to accessibility, with respect to all discovery, and ergo the clawback, with the hope that if you get everything you ask for, you're going to stop. It's going to ask for less because the volume is so big that it's going to encourage the demander to sort of tailor their request to manageable doses of information, because the amounts of information is just absolutely staggering. And in Professor Perlin's reporter's notes, he mentioned terabytes and how many billions of pages that could be. And so we've got to bring this. We do have to we got to rein this in somehow. And we're doing this by attacking the supply side, the demand side. I'm sorry, not the supply side. The clawbacks provision, which is essential to all of this, because if we're going to have electronic discovery, if we're going to produce it electronically, it's going to be done. You're not going to sit in warehouses reading documents and looking at every piece of, or every possible set of data. The clawback we added to Rule 26 B, because that was the section that was added for privilege, for the privilege logs, I guess about 5 or 6 years, no, I guess about 10 years ago. Time flies. So, and we've added subsections B and C. 26B was 26BA was 26B up until well, it is now until January 1st. So subsections B and C are the clawback provisions that have been added for with respect to these ESI amendments. And subsection C, you'll note, allows the court, if they follow the procedure, which is outlined in B above, to uphold the privilege or protection in a written order, and the key words are the disclosure shall not be deemed a waiver in the matter before the court or in any other court proceeding. And that's the carrot to go out and get an ESI order signed by the judge, because that will go beyond the litigation at hand. At least it potentially can. Now, the fourth area that Mark Perlin talked about is spoliation or protection of ESI that's lost in normal operation of business. And we handled this by adding a subsection to Rule 37, Rule 37 being the sanction sections. And that section, the new subsection F, it reads in its entirety, I think, exceptional circumstances, a court may not impose sanctions on a party for failing to produce ESI lost as a result of routine good faith operation of an electronic information system. Now, this proposal was criticized for being not broad enough, not specifying that it may require a party to suspend its normal routines in order to either prevent the loss of information it has a duty to preserve. We added, and that we dealt with that criticism, or I didn't deal with that criticism, I should say. Professor Perlin added a reporter's note that says that this added section does not affect the substantive law in Massachusetts in any way. And it is not intended to change any existing law in Massachusetts on the obligation to preserve evidence when litigation is reasonably anticipated or commenced. So the rules of spoliation remain as they were. This is safe harbor for ESI that disappears in the normal operation of a business. There's some other changes. We've added the term electronically stored information was added to the title of Section 34 because this is where the requests for discovery come from. With the amendments to Rule 45 and summonses that put a burden on the party sending a summons to a third party to take reasonable steps to avoid imposing undue burden or expense on a person subject to the subpoena. And so that sort of, in real quick, really quick survey covers the issue. And of course, Rule 16 was amended to add the topics to a Rule 16 conference. I think they were mentioned before, basically to allow ESI to be discussed in a Rule 16 conference. And finally, I just want to take a moment, wrap up on metadata, because not only did Mr. Berryman explain how important metadata was in his But I think it stands for, it answers the question why it took 6 years for us to get there. We had proposed these, I took over as chair in 2008, according to that bio, and appointed Fran to be the subcommittee chair. And the subcommittee met diligently and proposed the rules. We talked about them and hashed them back and forth. We came up with a set of proposed rules. They were published, as we normally do, in the Lawyers Weekly, and we thank the Lawyers Weekly for being a sponsor today. And we got we expected a ton of response and got very little, and it was all fairly positive. So what we do is typically send it up to the SJC, explain, and I forwarded everything to the SJC over 2 years ago. And then suddenly there were comments made directly to the SJC, and we dealt with those comments. And then one of the justices simply said, "What about metadata?" This is after we'd done this whole thing. And we raised that at a meeting, at the end of a long meeting. What about metadata? And the committee was exhausted, and we said, "Nah. If it's not ordered or agreed, we're not doing. No, forget metadata." That was it. And a day or two later, we started to think. In fact, I think it was Fran Fox who made the first call, saying, "Wait a second. You really got to have some of that. You know, when you send an email, you want to know. When you ask for an email, you want to know who sent it. When was it sent?" So we reconvened and we started talking about it. We actually had three full meetings. And this is a committee that meets only as needed, a couple times a year sometimes. We had 3 full meetings where we talked about nothing but metadata. In fact, I'm looking at Diane Barry. She came as a guest of one of our members, Peter Sachs, who's now the Commonwealth solicitor. And we were so grateful for Diane because she's the one who taught people of my generation, what metadata is and why it's important and how much there is out there. So when we learned that the average email has 25 to 30 fields of metadata, we started thinking, well, gee, maybe we should. This stuff is necessary, and we look to the analogs, the proposed uniform rules. We look to the feds. Feds don't require anything. The uniform rules don't mention it. Proposed uniform rules, but we do know that certain districts in the federal system require intrinsic metadata. We thought, well, what about reasonable metadata? Well, now we start talking about what's reasonable, what isn't. And then we learned that, wait a second, the fields of metadata are so much different for that which is transmitted from that which is kept on a standalone computer. I think that's the right term, but on my desktop. So then we actually proposed, we had different sets. We had we had a rule with 2 different subsections with what metadata would be required if the underlying the data to which the metadata attached was transmitted. Then you'd have to supply this set. If it wasn't transmitted, then it would be a smaller set. And then we found out, wait a second. Diane tells us, no, do you know that the number of emails is declining in the country, in the world, rapidly? Because young people, younger than you, don't email anymore, they text. And that's a whole different set of criteria, a whole different set. And the more we talked, the more we realized we can't do this. It doesn't the rule-making system does not lend itself to making these specific demands because the rule-making system, the process, is cumbersome by nature. It's intended to be that way. We talk, we consult, we go back and forth. And yet the world of technology changes, at a blistering pace. So we ended up exactly where we started out, no metadata. Except we did put metadata in 2 places. In the agenda for an ESI conference and in the list of purposes of a ESI order. What about metadata? Deal with it there. We want you to deal with it when you meet together. If not, leave it up to the judge. But I can tell you, if the judge is someone of my vintage, you better have dealt with it or come to court being able to inform as to exactly what you need and what you want. Because a lot of us don't get it. So the metadata thing really does stand as a token or as a symptom of the whole situation. We worked real hard to pull this together. We hope they're useful. But we do need input, and that's the other side. My final point to you is, if these things aren't working, I say they'll work because I hope they'll work. But if they don't work, or if they'll work better, and that's more important, let us know. You can write to me, you can write to Chris Burek at the SJC, she's the counsel to the SJC. Our committee is reactive. It's a standing advisory committee to the SJC. We deal with, when we hear that there are changes in the federal rules, we look at them and compare them to the state. When issues are sent to us by the SJC, we deal with them. Occasionally the SJC puts something in a decision saying, hey, we're looking to the Standing Advisory Committee for an opinion. We'll deal with it. If you write a letter, we'll get it. Because we want to make them better. We want to make this, but we don't want the rules to be constantly changing. And that's the overarching consideration. So good luck with the rest of the conference, and it's been an honor to talk to you.